perhaps we just go like this. I'll start with Joké.
So I will take the question on universal jurisdiction. I think, that is actually the hope and the desire that states within the African continent that have a universal jurisdiction as a framework that could be used, that they actually use it to help address and help have some form of accountability for what's going on in Sudan. Now, the reality, as we discussed earlier, is, political will is a big issue, and there are some states that may be able to use universal jurisdiction, but may also have a stake in the game or maybe unwilling to actually do so. So part of the work is thinking strategically to look whether within Africa, externally, just to look to see which other states may not be so close to the conflict in some way and may be willing to apply universal jurisdiction to bring cases, documented cases. And then with respect to civil suit, I think, again, it depends. There are different countries where survivors are able to bring cases. So for example, in the US, you have the Alien Tort Act. So it really just depends if they meet whatever requirements that the law states, but it is possible in some countries to bring a civil suit, not necessarily always a criminal case.
Thank you. I'll respond to Amir's question. Just to distinguish two things, extraterritorial jurisdiction and universal jurisdiction. Now, in the context of Uganda's ICC Act, Section 18, as I mentioned earlier, one of the grounds in which the court may exercise jurisdiction is if a person who has committed any of the Rome Statute crimes is present or resident within the jurisdiction of Uganda. So this person has to be present in Uganda and to demonstrate that they have committed crimes in Sudan, but they must be physically present rather than draw up charges and wait for the person to come. The court would not do that. Then in terms of civil suit, I would encourage that rather than even looking at civil suits, looking at regional mechanisms, using the East African Court of Justice, using the African Commission, making sure that all these complaints are presented to draw up momentum for accountability and redress for victims. Then the other is, someone mentioned the geopolitics, and I just wanted to emphasize one point. I'm glad that we are having this different fact-finding missions at the UN, at the African Union level, the African Commission, but we're also having political processes underway. The high-level panel on Sudan, spearheaded by the African Union. It is important that the question of accountability is part of these mediation efforts. The question of addressing the violations is part of these mediation efforts. And these documentation processes are key in demonstrating why this needs to be done. So there must be that linkage. As we talk about collaboration, it's important that all efforts of accountability feed into the political processes to end the conflict. Thank you.
Thank you so much. I think 2 or 3 questions that were raised, I'll respond to those. Amir, human rights defender, and I think there was a journalist. Underlying all of that is to say that when we talk about accountability, we're trying to chip away at structural problems that don't necessarily go away with one case. And that's why I was using the example of the incremental build-up, identifying strategic opportunities to keep chipping away at the problem. Because we're living in 2 worlds and 2 realities. And that speaks to building the movements, that speaks to identifying opportunities. For Amir, in fact, I'm sure you do recall that a couple of years ago, through the leadership of ICJ and other human rights organizations, we did file a petition in the Kenyan court when President Omar al-Bashir then visited Kenya for the inauguration of our 2010 constitution. And as a result of political connivance, he escaped the net. But suffice to say, the judiciary did live up to the expectation that they would speak out and, in fact, affirm that Kenya had an obligation to arrest a fugitive of that nature when he was within our territory. In the same spirit, whether it's the reading of our existing laws that offer the possibility for extraterritorial jurisdiction, for instance, with regard to torture. So it does not necessarily have to be coming within the International Crimes Act. There is an opportunity on the grounds that Sarah spoke about. Are the perpetrators within our territory, or have certain violations been committed within our territory? There may be perpetrators within our territory as we speak. The fact-finding mission could advise, but those are really avenues that can be used, and I like that you say, you're calling it hypothetical. It's our next new reality. We must test and push the boundaries. And why wouldn't an advocacy ask be to the government of Kenya to start a hearing? Why not? What law stops us? None. And I think that's the kind of push and move that we have to bring within the space. That rather than default on what frustration and fatigue brings, let's hopefully be able to bring each other and keep inspiring each other to push beyond the boundaries. That is how we've had Baby Pendo. That is how we've had Koyelo. That's how we've had Hissen Habre. It was never what was on the textbook. It was always something new to build on. And so, yes, there is an opportunity within Kenyan law, but there could also be an opportunity within Kenyan political space to push for accountability. On survivors' movement, as I finalize, linked to the question that was asked, our brother was saying that the contexts are different. Indeed, they're different. But they're the same with regard to dealing with the structural problems. In Baby Pendo, we're dealing with state security officers' impunity. From post-independence, pre-independence, post-2010 constitution. And the excuse repeatedly has been, sorry, we don't know who hit Baby Pendo. Who was the commander? We may not succeed in this case, we may succeed. But the strong message behind this is, we never want again to hear a police officer hide behind command, structure, operation to justify the killing, the raping, being used as a political instrument against the people. We have a long way to go, but it's one step in the right direction. South Sudan, we're asking for a hybrid court. Just the day before yesterday, we were in a state called Warrap. They have passed their own penal code called a Green Book that says if you kill, we kill you. And in fact, they've been killing. And that is their way of saying, because we have no administration of justice system, the entire Warrap has one president of the High Court, one. Now, the community is left helpless, and they're looking for their own solutions. While at it, they are further diminishing the prospects for respect for the rule of law. And that's why I go back to the issue of it will manifest in different ways, but we cannot lose sight of the fact that we are fighting structural problems. And we find opportunities in time to incrementally build on that fight. And that goes to movements. Kenya has led the way. Who knew we could stop a finance bill through Twitter? It's the new reality. There are many victims, but we must move away from this formalistic. In fact, those of us who work with survivors are very apprehensive to making survivors civil society. They're not civil society. They have their lived experiences. Their lived experiences bring them to the table, and we must keep it that way. So where are they? Is it children? Is it women? Is it those in the remotest part of the country? The task we have is to make sure that along this long trajectory towards justice, we keep the human face alive. Who is this about? Why is this about them? And how are they engaged? Can we hear them? Can we see them? Can we repair them? And not at the end of the long criminal trial, but as soon as the opportunity makes it possible. I'll stop there, thanks.
After that very powerful submission by Tina, I'm tempted to say I have nothing useful to add. But let me answer young Doro. You know that the whole debate around command responsibility is not new. You know, from 1899, the Hague Conventions, 1907, the Nuremberg trials, it's been there. But for us, it looks new because it is being tested in Kenya and other areas in Africa for the first time. So that's why we are still worried. What are its parameters? What are its bounds? You know, what does it mean? But it's simple. It just means that the commander should take responsibility for the acts or omissions of his subordinates. And Antina has spoken better than I could ever do about how it's being used as a defense to say, but look, I took a command or I didn't give the command. But again, the Baby Pendo case will be the test case in this country. In the Japheth Koome case and the Human Rights Commission, I wouldn't fault the judge because it is his reasoning that in this particular case, he couldn't see that Koome had any command responsibility. Remember, the operative word is command and responsibility. So if the court couldn't find it, then it has to be tested on review or a higher court to determine that he did. But the bigger point, and I think Tina has made it again very, very well, whoever imagined in 2010, 2013, when I was heading the Human Rights Division of the High Court, I never had a case like this where anybody would sue the Inspector General of Police to take a responsibility for what subordinates do. We didn't do that in all these years. So again, we are chipping away at these blocks by this kind of case. That judgment will be developed by another. Another judgment will come, it will be developed by another. So it's one step at a time. And so this should not be taken as a loss. I recall Wangari Maathai, Betty Murungi, remember this. The late Wangari Maathai filed a case to stop the building of a high-rise building at the Uhuru Park, which a lot of you know is a beautiful, scenic park in Nairobi. And when she lost the case before the High Court because of technicalities, she said, sometimes you win by losing. And the truth be said, by filing that case, by trumpeting, highlighting the environmental effects of that building, nobody put up the building, we still have the park as it is, she won by losing. So don't imagine that any case you lose in any court is necessarily a loss in the ultimate. In fact, you may just make gains, you may make wins by filing this kind of case and opening the parameters, the boundaries of justice and jurisprudence. So that is, I think, a good takeaway from that case. As I close, because I won't have another moment with you, if you carry nothing from this conversation, I think for me the takeaway remains, let us never forget the victims. I spoke about it when I said, we as judges, we as prosecutors, we as civil society must be strong in fighting for the victims. Because ultimately, we may be doing our job to earn a salary, but if we don't fight for the victims, what business do we have to be in the offices we are in? And so carry nothing else if you must, but think of the victim every single time you sit as a prosecutor like my friend Nyongesa or a judge like myself. That is the ultimate that we must think about. I thank you.